Welcome to Walatu, Walasa, your weekly Labor Digest program on Clock TV, Beyond the Policy. Here we examine labor institutions, laws, and policies shaping Ghana's world of work. I am your host, Edmond Akwe. You can watch Clock TV on all our social media handles, Facebook, YouTube, TikTok, and on Channel 184 on GoTV. As we continue our Labor Department series today, we focus on the Legal, International Relations, and Workmen'S Compensation Unit. The unit responsible for labor law interpretation, international labor engagement, and the protection of workers through the Workmen'S Compensation Framework. In this episode, we examine how labor laws are applied in practice, how Ghana's international labor commitments influence national labor policy, and how the Workmen'S Compensation Act protects workers in the event of workplace injuries and occupational diseases. Joining us to do this important discussion is no other person but Mr. Francis Bubusi Esquire, the Assistant Chief Labor Officer with the Labor Department. So you are welcome to Walatu, Walasa.
Thank you.
How are you doing yourself?
By His grace.
Great.
And
We just
yourself?
came back from the Christmas break. So
So we are continuing.
Walatu, Walasa is doing very well. We are
Yes.
doing great, and it's good to have you here on our program. We had already started with the Labor Department. We have discussed certain areas of units within the department. Today, our focus is on your unit, the Legal, International Relations, and the Workmen'S Compensation Unit. Tell us about this particular unit within the Labor Department.
Thank you very much. And I really appreciate the opportunity offered us to be here this very morning. In fact, we have been looking for such opportunity to showcase what we do as a department, not only the unit. And today we had the opportunity. And we are indeed grateful to you and your team as well.
Thank you.
With respect to the Workmen's International Relations and Legal Unit, it's one of the divisions within the Labor Department.
Great.
We are not working in isolation. We work as a team. You know how the economists will always say division of labor. You can't put the entire work on one particular unit, so you have to segregate and give each one a task to perform to achieve the goals or the objectives of the department. And also being a public institution created under the Constitution within the Articles of 190, we serve as an institution that is mandated by the law, both the Constitution and the Act of Parliament.
Yes.
So when you look at the work of the Legal, International Relations and Workmen'S Compensation Unit, in fact, it's very broad, as the name even suggests, so long.
So long, it is.
Yeah, so in the first place, we look at the functions of the unit. The unit is currently having 3 lawyers headed by a senior lawyer.
Great.
And we have other supporting staff within the unit. And our core function within the unit is to provide technical advice to the Chief Labor Officer with respect to the various provisions that he requires further explanation or interpretation to resolve issues that might have come before him in matters of dispute among employers and workers, could be individual worker or workers' organizations.
Okay.
So the unit is a very key one, but it does not take the mandate of the Office of the Attorney General and the Ministry of Justice, which is the principal legal person for government. So we still work under them, but this is an internal unit that provides internal advice based on legal tenets within our operations.
Yes.
So what we do again is that in respect of international instruments, international in respect to especially ILO conventions, protocols, recommendations, and other resolutions.
Yes.
So when these instruments are adopted at ILC, if I say ILC, meaning International Labour Conference. So it will come to our desk for us to summarize the convention and advise the Chief Labor Officer whether or not that particular instrument is capable of being ratified by Ghana government. If yes, then what steps? If no, what is lacking?
Yes.
Then we advise the Chief Labour Office before he also go and brief the Honourable Minister responsible for labour, jobs and employment.
Yes.
Now, we also have issues of legalities in court. Some of the unions and other people, mostly the unions, have taken Chief Labour Officer to court.
On various issues.
Yes, on various. Even some are still pending as we speak today.
Great.
Yeah, especially where there are multiple unions within the same establishment.
Working
yes,
conditions.
establishment. So they seek to identify who is having majority. Some are dragging their feet for the processes to continue before others are in court. So we also provide that. And what should the Chief Labour Officer tell the Office of the Attorney General? Because they are going to be our lead lawyers in discharging that particular mandate. So we also have issues of investigating and determination of workmen compensation, which we'll be dealing with later in our discussion.
Very well.
And we also have issues of conducting training for our officers across the country in respect of labor laws. Because some of us, we had the opportunity to be trained and be nurtured in terms of law. So we seek to inculcate this into our colleagues who are also labor officers, so that we enhance their operations. Because everything we do has to do with law. As a public institution, we cannot do anything outside the scope of the law. And that will be, in fact, you face a lot of legal...
For the purpose of our viewers, talking about law, we do want to outline some of the legal instruments that you work with.
Oh, yes, very well. Thank you very much. We call it tools.
Tools, great.
Our working tools. The principal working tool that we have is the Labour Act, 2003, Act 651. This act actually repealed the Industrial Act of 1963.
Very well.
And it also came out with a regulation, so we call it Labour Regulation 2007, LI 1833. Even though there's another LI, that one is under the ambit of National Labour Commission. That is National Labour Commission Regulation LI 1822. Then we also have Domestic Workers Regulation 2020, LI 2408.
Yes.
And then we have Workmen'S Compensation Act 1987, PND 187. Then we have Occupational Diseases LI 299, 1963. That is an adjoint law or maybe legislation backing the Workmen's Compensation Act. And our mother law also deals with the Constitution.
The overall Constitution.
The overall Constitution.
Great.
That is where we also have the power. Even most of the powers of the Labour Act derive from the
National Constitution. Yes. Great.
So these are the tools that we work. And also, we work with the tools in terms of the unions. They have collective bargaining agreement, and the law mandates to deposit same.
Great.
So in the event there's an issue, we refer to that document. So it's also one of the tools we use to work.
Great.
And they also rely on the court decisions as one way of also using it in other activity when we are doing our operation, because the Labour Act itself is not extensively to cover every situation. Some of these issues are being resolved by court, and but it also becomes a law, which we are supposed to comply.
That is quite interesting. Now, let's look at talking about some of these laws that you've mentioned, you've outlined. Okay, we are going to touch on each of them one by one. Okay, let's look at what is interesting to me is the domestic workers. You mentioned it.
Domestic Workers Regulation LI 2408. It is a law that was promulgated to be in tandem with Domestic Workers Convention 189. Even though Ghana is now working to ratify that convention. And when you look at the act itself, it has made provision for every worker. But this particular sector of workers were not really captured well in the Act. So the framers of this LI thought it wise that no, they are also workers within the meaning of a worker. So why do we leave them out? Their fundamental rights are being abused. So in order to avoid that, there should be a law to back their operations.
Okay.
Hence the promulgation of that LI 2408.
So currently, as we speak, we have domestic
workers regulation. As far back in 2020.
Yes, so we have domestic workers working within various houses and various establishments.
Individual homes, could be a company, it could be you yourself. You may even have one.
Okay.
And within this particular LI 2408, it requires that anytime you engage a domestic worker, you need to submit to any labor officer within the district a copy of the contract of employment.
Yes, that's where my question comes in. Do people follow this particular procedure?
Yes, some do. Others, I may not necessarily say ignorance of the law, because ignorance of the law is not an excuse. Some do, but majority are not doing.
Okay.
And it may be due to insufficient sensitization like we are having today. So maybe today may even be a day somebody is even hearing that we have domestic workers regulation, regulating domestic workers.
For that matter, if you want to engage somebody as a domestic worker,
it should follow due process, because the law itself has outlined the process to follow. Even in signing the contract, what should be in the contract?
Yes.
The law itself has made that extensively. How much the person will be earning, the leave, Senate contribution,
and all that should be taken into consideration.
Exactly.
Yes. This is interesting. Why? Because domestic workers themselves would be quite illiterate. Yes. Okay, so some of these they might not know, and we know a lot of people are going through domestic abuse. Domestic workers are going through domestic abuse because of the treatment that is being given to them within the working environment that they find themselves. That's interesting. But earlier on, you made mention of a key word: bargaining certificate. Can you please tell us a little bit about what you mean by bargaining certificate?
Yes, okay, thank you. When you look at, before a union to operate or negotiate with an employer, you need to be licensed by the chief labor officer, even though you have incorporated with the Register General as a corporate or as artificial human being.
Yeah.
Now, that one alone does not suffice for you to go and negotiate with your employer. So you need to have collective bargaining certificate. That will give you the power to negotiate with your employer. So if you register a union and you do not have collective bargaining certificate, you cannot negotiate with your employer.
Yes.
But some people are doing that. I have a case where somebody approached me. The union went in to do negotiation. They did the negotiation
with the employer.
Meanwhile,
they don't have bargaining.
They don't have collective bargaining certificate. And my attention was drawn to. So what is it? If you don't have the power, capacity to do something, and you went ahead to do it, everything done is void ab initio from day one. So everything that they have in that collective, that alleged or purported collective bargaining certificate, is null and void.
We don't see day of fly.
It cannot fly. So that is it. So collective bargaining is it's a legal instrument. Even the law even requires that any time they issue collective bargaining certificate, it should be gazetted. It's a legal document.
Okay. Yes. So the collective bargaining certificate gives the union the power to be able to negotiate
to sit with the employer,
with the employer, and that is awarded by the
chief labor officer.
After what? What would the chief labor officer watch out for?
After they have certified the conditions,
that collective bargaining certificate.
Yeah, after they have certified all the conditions contained in the Act itself. The Act itself has made provision or procedure how one should follow to acquire collective bargaining certificates. Okay. Maybe, for example, where there are more than one union within the same establishment or the same company, the law is clearly provided the one with majority should be the one having the CBC.
Okay.
to lead the negotiation. But it doesn't mean the minority should be left out. They should also be brought in. But the lead discussion will be done by the one with majority.
Okay.
And how do you even identify the one with majority? You need to conduct certain interviews, investigations, among others. It could be through payroll, it could be through headcount to know the one with majority. It's not just to just look and say, you have come early, so you have majority. No. So the two unions are brought on board for all this discussion to be done. It's not done by only the chief labor officer.
Right.
He brings these unions all on board, then they have a discussion as to how to go about the verification. And when that is done, then the one with the majority should also issue the certificate. If initially there was only one union, but in the near future there is another union, and the current union is having more members than the
new one.
The new one is having more members than the old one. But meanwhile, they were having the CBC. The law is that they have to conduct verification. If indeed proven that the new one is having more majority, the children have to revoke the old CBC and issue the new CBC to the one with majority. And that is where always there's a problem.
I was going to ask if it happens. Has the chief labor officer gone through such a tangent?
Oh, yeah, we've been facing. In fact, when it becomes that's where there is confusion. This will not agree, the method used is not correct, we are not there, we are not consulted, a whole lot, and some will end up in court. And that's why I'm saying there are a lot of issues like this pending in court.
To address some of these
issues. So we leave it for the court to decide.
Exactly.
So we know what's supposed to be, but we leave it for court.
Viewers, our conversation is getting much more interesting. Now you've touched on the domestic. Now we've looked at the domestic workers
regulation.
Regulation. We've looked at the collective bargaining certificate. Now there are two other ones that I would like us to touch on, but we'll go for a break. And when we come back, we'll look at the Workmen'S compensation unit of the Labour Department. We'll look at what Workmen's compensation actually means and what they go in for. We'll be right back.
Walatu, Walasa, Daddy, I want some. Walatu, Walasa, Daddy, I want some. Yeah, mirisu mi won't na mirisu mi kura. Mambo, Daddy, I want some. Yeah, Walatu, Walasa, Daddy, I want some. Yeah, mirisu mi won't na mirisu mi kura. Walatu, Walasa, Daddy, I want some. Yeah, mirisu mi won't na mirisu mi kura. Mambo, Daddy, I want some. Yeah, Mambo, Daddy, I want some. Yeah.
Welcome back, viewers, and we are on your show, Walatu, Walasa. We have in our studio a beautiful gentleman who has been walking us through the legal, international relations and workmen's compensation unit of the Labour Department. Mr. Francis Bubusi Esquire, thank you so far for the good work you are doing for us here in our studio. Now, workmen's compensation, what do we mean by that? Can you please elaborate on this particular technical word that we are hearing today on our program?
Thank you. Workmen's compensation is derived from the common law principle. And it is basically mean that when an employee is working for the employer, and whilst working is involved in an accident or sustain an injury or is contracted with occupational disease certified by the medical officer, then the law says that it is because of the work you are doing. That is why you sustain this injury or you are suffering from this. you should be compensated for that. And basically, it's also monetary compensation. It cannot be in kind or any other form, but only monetary compensation. And when you look at this law, it was as far back 1940. That was when Ghana government then developed Workmen Compensation Act.
Okay.
But by then, it wasn't, but later on, because now it's an act, so we are using an act.
Yes, we are using the act, yes.
But it did not start working in 1940, but in 1942, then it came to force.
Because something happened?
Exactly.
Great.
So there was a lot of discrepancies and misunderstanding and other things. But by then, let me give you just history about this whole law.
Great.
Those days, before you can benefit from workmen compensation, if your salary is more than today 6 pesos or 60 pesos, which was 600 cedis by then, you are not qualified. If you are qualified, they will not pay to you now unless when you are retiring. Then they will add it to your retirement package.
Is there a reason?
Yeah, because you are financially sound.
Great. So when you are paid around 60 pesos
at that time, you were financially sound.
That's amazing. Today 60 pesos is
yes.
Nothing to write home about.
You must also be admitted into hospital for 5 working days. If your sickness did not take you more than from 5 working days and above, you are not qualified for workman compensation.
Okay.
You see, and if you are also a senior officer, everything, you are not also qualified. So they were the people earning more.
Okay.
But the law has gone through a lot of reform due to economic reforms that we are. So as we speak today, after that, there was a committee that was set up to deal with and look at the economic situation and enhance all those things.
Great.
And that is why we have 1987. But it has gone through a lot of reforms.
Okay.
But the current one in operation, even though we still have challenge with the current one, which we are going to reforms very soon, we'll be discussing. And a lot of issues have been raised. Even the name itself, whether you are a man or a woman, you are called Workmen's Compensation.
So it covers both.
So the injured workman, whether you are a man or a woman, we call you injured workman. So those concerns have equally been raised.
Okay.
And now we are renaming it to become Worker Compensation.
Great.
Which will comprise every person, not limit to only man.
So currently the one that we are working with is the Act of 1987. That's PNDC law 187.
Yes.
Let me, for the purpose of education for our viewers, let me just say what it says over here. That in Ghana's labor space, Workmen Compensation Act, often called the Workmen's Compensation Act, is a protective labor law designed to ensure that workers are fairly compensated when they suffer injury, diseases, or death arising out in the course of employment. Now, let me ask a question there. Your unit, dealing with such situation, working with the Workmen Compensation Act, do you face a number of workers coming in reporting about injuries they have faced at workplace?
Oh, yes. Even though majority are not aware of this particular law, but those who know, they always come across the country. Mm-hmm. And I can tell you statistics or the data we have for 2025, we spent Ghanaian or employers spend no less than 51 million Ghana cedis in paying workmen compensation to various employees who have suffered one form or the other injuries whilst working, and also to the dependents of the deceased workman. So it tells you that people are really benefiting from this particular act. Mm-hmm. And the act is a social protection.
Great.
It's one of the social protection schemes that government has made available for every worker, with the exception of armed forces. Ghana Armed Forces. They are the only people that the Workmen Compensation Act does not protect. They have their own system of dealing with their situations.
Okay.
So other officers are governed by this particular law. And then the workman compensation is also a strict liability. If I say strict liability, means it cannot be transferred to another person. So if I'm working for you, have company A, and I sustain an injury, the liability is directed to company A. You are the one to pay. You can't say we should direct it to company B.
Okay.
Maybe you have some issue with your company B, you have transferred your liability. We know you.
Very well.
So, and the workman compensation is not depending on insurance. Whether you have insurance or not, once your worker sustains an injury, he has to be compensated after the treatment. And let me be quick to add that it is not every injury or accident that is compensable. But every injury or accident or occupational disease is medically payable.
Interesting.
Yes. Because the law requires that every medical expense with respect to that particular injury or occupational disease or whatever form has to be borne by the employer. But workman compensation claim kicks in after the treatment.
So at which point in time does your unit know that there has to be a workman compensation for a particular worker? Who comes in first?
So when you look at Section 120 of the Labor Act, it requires that within 7 days of the happening of any accident or occupational disease, the employer or even the worker himself is required to report to the nearest labor officer or any government authority. When you come to the Workman Compensation Act, within the sections of 10 and 11, it's also made provision for the reporting. Now, when it is reported, the labor officer will issue a form. We call it accident report form, sheet 1 and 2. This, at that point, the employer has already taken the worker to hospital.
Okay, so the employer is not left out. The employer is involved in the process.
It's involved in the process. Okay. Because the person is working with you and is with you and has sustained an injury. So you are the first person to even know before the parents of the worker or the family of the worker. Okay. So you have to take the person to hospital. Pay all the medical bills that is required of you. Even if you have to procure certain items that will aid the person, it is the responsibility of the employer. Now, when you do this, we expect that you submit to us a medical report from the attending medical officer. So the medical officer will tell us the extent of injury and incapacity or disfigurement. Or even if there's any functional loss of genital organ, the doctor will tell us.
Yes.
People do report that as well. If it is also occupational disease, you also tell us. Let me be quick to see. You see, when COVID came,
very well,
I'm trying to explain, I made a principle that all accident, occupational disease are medically payable, but not all of them are compensable.
Okay.
When COVID came, some workers contracted COVID
within the working environment.
They were taken to hospital. Even though I believe government subsidized all these things.
Yes.
But if government had not subsidized that, it would have been the liability of the employer to pay all the medical bills. Now, when they finish treating you, now they will have to look at whether there's any residual effect on you.
Okay, that would not make you to perform like you were performing
You're
before.
Performing.
Okay.
And that is the basis for the workman compensation.
Okay.
So if you are fully treated and there's nothing wrong with you, you are not back to work normal. Nothing is wrong, nothing.
Yes.
You are not to be compensated for.
But did some workers come asking for COVID compensation?
Oh, in fact, I received at that time about 50 claims from University of Ghana Medical School.
Okay.
But fortunately for me, on my part too, the doctor also was very good. He said not applicable. Incapacity not applicable.
So it did not make your work that difficult?
It didn't make my... So we wrote back to them that based on the medical report, they are not to be compensated.
Yes.
We sent a report back.
Great. So taking COVID as an example, let's look at some of the injuries that occur at the workplaces that you come across.
Okay.
You want to know the factories?
Yeah, factories. That is the highest. When you look at manufacturing, then before you go to construction.
Okay.
Yes. Then you go to mining and quarry. Then before you go to these individual businesses.
Yes.
Yeah. So when you look at the data we have in our office, these are the lead sectors that
most workers come
exactly. And the vulnerable part of it is that these individuals who sustain injury at the workplaces are people with lower qualifications, and they are paid low.
How is the workman compensation calculated? How do you come to the amount to be given?
Yes, so we have within the workman compensation the ingredients that we need in order to determine a claim. One, like I said, the medical report. That's the first thing. Two, the form that we submit, it should contain the salary of the worker.
Yes.
And then largely we need maximum 12 months of the worker's salary before the accident. Before the accident, not after the accident. Before the accident. So this law look at retrospective.
Yeah.
Now, when we get this, when you look at section 35 and other subsections, it gives us a limit as to how, when somebody is earning more than a certain range, we should not use the actual salary of that person, but to limit the person to a certain range. And I found it a way to prevent discrimination. Okay. Because if I sustain an injury, we all lose this our term. You also the same pain you feel, the pain I also feel. But because your salary is high, you receive more than what I will get. So I believe the framers of the law thought it wise that no, let us have a cap.
A cap.
We should have a cap. That if your salary is more than this, you should not
benefit.
You should benefit, but you should use this amount for you.
Right.
And that is why we have up to date. So in each year, we have what we call ceiling. And it is based on the high executive officer in active service from Office of Civil Service. So the annual salary of that, the entry point of the high executive officer salary annually. So if your salary is more than that, we'll use that one for you. But if your salary is lower than that, we'll use your lower salary.
Is there not any form of discrimination for the lower salary person?
You see, apparently, it's not a discrimination. Okay. When it becomes, possible for us to adjust it, that is when you are paying your worker below the minimum wage. For that one, we'll use automatically adjustment to be
exactly the whole compensation process. So now, do employers conform to the paying workmen compensation?
Oh yes.
Do they conform after you have finished calculation and you've given them that this is the compensation that you are supposed to give to the worker?
Yeah.
Do they conform by paying?
The majority conform. Majority, because the law also gave
time frame.
Within 3 months, upon serve of notice of the determination, you have to make the check available in the name of the worker. Then you come to the Labor Department, we witness and sign deed of agreement with the worker and then the employer. But if the employer pays under Section 15 of the Workmen Compensation Act, if the employer pays the money to the worker without a labor officer, and that person is an illiterate, the word that they use the word illiterate.
Yes.
The person, and with that labor department or labor officer, the person can come back and say he needs more money, or he can go to court. But when the labor officer is involved, he will sign deed of agreement with the injured workman and the employer, and by way of explaining that this amount you are taking is in respect of the injury you sustained on this so and so date. And this is the money that was determined by the Labor Department. Do you like it or not? Because whatever we determine is not compulsory for you to take. You can also take an independent action to retrieve whatever you want to, but not just that whatever will compete is finality. No.
Okay.
The law made provision for independent action by the worker.
Yes.
The worker can also take independent action. But in view of that, you cannot take the check with and then go back to court.
Yes.
Especially when the labor officer
has signed. The arbiter.
Exactly.
At that moment, the labor officer is the arbiter to ensure that the compensation goes on smoothly.
Exactly.
Now, would some employers, say that we are not paying this compensation? Why? Because it was the negligence of the worker.
Yes, we have had that. Quite a number of them. You see, the moment an employer raises an issue of negligence, Labor Department cannot entertain that case.
Okay.
Because negligence is to be determined by the competent court of jurisdiction.
Okay.
So go and prove your negligence there.
Yeah.
So we'll refer the parties to court. Okay, this is what the employer is saying. He's saying that you caused the act.
Yeah.
So in view of that, he's not willing to compensate you. So if you think you also have a case, maybe then you go to court. But in the first place, we'll invite the parties to try to explain to them if that is workable.
Yes.
Maybe let us know why you are saying negligence. What did he do? What happened? So if you are not able to resign, we'll make sure we refer you back.
Okay.
Even there are a lot of cases that goes to court and come back to the chief labor officer's desk. The judge will refer the matter for the chief labor officer to do the calculation.
Yes.
But when you go, if you are going to court on the principle of negligence, you must go to high court
first. After ignoring the ban.
Yeah.
After.
If it's about negligence, you have to go to high court. But if it's about just a common compensation under the Workmen'S Compensation Act, you can go to district court, you can go to circuit court, irrespective of the amount involved. That is the position of the law. And if the injury resulted to death, the person dies.
Yes.
The law is that we pay 60 months of that person's or the deceased workman's earnings to their dependents.
Okay.
60 months. But when you die, by the case of Quasin and another verse, the Labor Department, 1977, it's High Court, Takoradi. That is the base upon which now we use the 60 months without using the ceiling. The court ruled that the law says earnings. And when you look at Section 38 of the Workmen'S Compensation Act, the earnings is defined there to include allowances.
In totality.
Well. Except maybe ex gratia or one-time payment in terms of some per diem. That one is not part of it. Any other thing that comes to you every month should be consolidated. Then they pay that
60 months.
60 months. So if you are earning 30,000 Ghana cedis and you sustain an injury and you died, 60 times 30. That is what will be paid to the dependents. And this money that has to be paid through court under Section 11(1).
Yes.
It has to be paid to the court. And it is not depending on PNC Law 111. There are a lot of employers who have been making mistakes. In terms of fatality,
it has shifted away from.
It doesn't form part of PNC Law 111.
Yes.
And we don't use letters of administration to pick workman compensation claim when the person passed.
Okay.
We don't use LA.
We don't use it.
Because the LA is applicable to estates or properties that somebody acquired when he was alive. But he did not make a will by way of disposing them before he died. So he died intestate. So you need letters of administration.
Like a property, a house, a store, Exactly. Great.
But before you even die, you don't know how much was coming to you as workman compensation. So it can be part of your estate. That is why we don't use LA.
Great.
And when you look at the second schedule of the Workmen's Compensation Act, it has clearly outlined who are the beneficiaries. It's not a family money. Who are the beneficiaries to the deceased workmen's compensation claim?
So that one does not go to a Busia paying?
No. Though we may need a Busia penny to come and give us brief about whether the person was married, if he's married, how many children, who and who, where are they, so that we can assemble these people and then apportion them and go to court for court order before we disperse it. Recently, there was a case like that. The man was just following up, thinking the money will go to. So when the company called us, said, please issue the check either to court or to Labor Department. We will go to court for court order before the money is released to the dependents. Even the man, I told him in his face that even one CD will not come to you. But after all this, the beneficiaries can decide to mobilize something and give it to you as your transport.
That is the Busia penny you were talking about.
That's the Busia penny.
Viewers, workmen compensation is very, very important. If you are at a workplace and you don't know about this, today you know. Be careful how you work within your work environment, because workmen compensation, although it's there to ensure that you are compensated, when you get hurt or get more injured at the workplace, you might find yourself wanting. We will take a break, and when we come back, we'll look at the other areas of the legal unit of the Labor Department. Then we'll call it a day. We'll be right back.
Walatu, Walasa, Yadi, Awonso, Ayiwa, Walatu, Walasa, Yadi, Awonso, Ayiwa, Mirisu, mi wonwu, na mirisu, mi kura, Mambo, Yadi, Awonso, Ayiwa, Walatu, Walasa, Yadi, Awonso, Ayiwa, Mirisu, mi wonwu, na mirisu, mi kura.
Welcome back, viewers, and we are on your show, Walatu, Walasa. We have in our studio Mr. Francis Bubusi Esquire, who has been walking us through the legal and the international workmen compensation unit of the Labor Department. Now, Mr. Bubusi Esquire, let me just touch on this. Before we went on a break, we were dealing with workmen compensation. Now, I want you to know, for the purposes of our viewers and also for any worker who is watching us, what are some of the challenges in enforcing workmen compensation?
Yeah, thank you very much. In fact, there are a lot of challenges. Largely, the medical reports. Because the doctors are not conversant with the act itself. The act has prescribed certain percentages for some parts of the body, but this is not known to doctors.
I see.
So the doctors' report will come with some different percentages, which you may have to write back. And when it gets there, the doctor will tell you that he is a doctor and this is what he has assessed. So to resolve this, you may have to make a photocopy of that section of the law and attach to the letter again and send it
to the medical facility
to comply with it. Though they are medical doctors and they know health issues, we are enforcers of the law.
Of the law.
Employers are not reporting this workplace accident on time. Even some are not even reporting at all until there is an inspection or somebody has come across an injured workman to the center asking whether he has been to Labor Department. That is why you now see them
coming in.
You see, when you look at section 12 and 13 of the Workmen's Compensation Act, there's a time limit for one to apply workmen's compensation.
Yes.
The law says within 6 months. Even when somebody dies, within 6 months, you have to report to the labor office. But some are aware, the employers are aware of this accident, but they will wait more than even a year.
Before they would.
So when you go further to the law, it says that once it has come to the notice of the employer and the employer failed to take reasonable steps to report it to the nearest labor office, it has not precluded the worker from claiming workman compensation, even though it's more than 6 months.
The worker can still go in and
Yes! I have matters before me as far back 2003, 2004. They are now reporting. It's not the case that the employer was not aware. So when it happened like that, we have a discretion.
Yes.
We'll look at the similar position of that officer
Yes.
and the earnings of that person now. And we'll presume that the incident has not happened.
Use the current
Exactly.
situation,
Exactly.
monetary situation.
But when you
to calculate.
go back to 2002,
Yes.
how much can you pay the person today?
So you think it might be intentional for certain employers or
Yes, some are
certain
intentional.
workers would not go and
Yeah, some
report
are
immediately?
intentional, and some even have their own internal resolutions.
Resolutions, okay, yeah.
Oh, you don't worry, don't go to any place. We'll find you this. Let me tell you one issue. This guy was working for an employer around Wager. When he sustained an injury, he told the employer that his mother is having a land somewhere around Amasaman. So the employer said, he asked them to give him some 2 trips of sand and some blocks so that he can put up 2 bedrooms. He did that. When this guy left the office, he came to our office to report
Meanwhile, he has received
that he was working with this so and so. He sustained they didn't do anything for him. When we went in, there was no documentation. Even what we did, there wasn't any evidence to show that it was in relation to that. You know, I first mentioned that workman compensation is monetary compensation.
Yes.
So we did a new compensation and the man paid.
A lot has been happening. Now, let me ask my final question on the workman compensation. After you've been compensated, would you go back to that particular workplace again?
Yes.
You can go.
You can go. Even with this Section 50 of the Labor Act provides that if you sustain an injury and after compensation, maybe the doctors may even recommend that don't go and work where you were working before.
Yes.
Maybe they should give you a new rule. If there's no new rule, that is when the employer can say that I have no rule to give you anymore, so you have to go. But by virtue, because of the injury you sustained, you are sacking the person. It's unfair labor practice.
It's unfair labor practice. And that can also come to your desk and you address.
And be addressed, of
address it.
course. Of course. Even let me add that when you sustain an injury, whilst treating yourself, the employer must continue to pay your salary.
Yes.
Whilst you go through the medical treatment.
You see, Walasa wants to know whether the employers are doing this because come talk about it. You see a lot of people walking around. Oh, my arm is no more there. Why? Because I was working in this factory and this is the injury I got, and yet they are going through a lot of economic challenges.
Yes. So that is, you see, another challenge we also face is about our numbers.
Okay.
Our numbers. Because some of the issues can be detected during inspection.
So you want to talk about challenges that the labor...
No, in terms of, the unit, in terms
unit.
of maybe why some people are not reporting or some claims are not coming.
Okay.
Are you getting me right? Because some may even tell you that they've not even heard of that.
Of course, it's true.
Even, I will not even mention, I went to a court.
Yes.
For order for this payment of workman to the dependents. And the judge told me that this is the first time
He's even hearing about
that by
that.
workman compensation.
Which act are you deriving
So
it from?
even if a whole judge will say this is the first time,
then you can imagine, factory hand worker.
somebody who's, who sleep with law, eat with law, drink with law.
Yes.
He said this is the first time.
Otherwise, the law is in their bosom. That's quite interesting. That's quite interesting. This Workman Compensation Act is very, very interesting. I think I like it. Why? Because at least it gives some kind of compensation to the worker that, after all, wasn't lost. After this major injury that happened to me, I've been compensated in the way. Otherwise, my families have been, compensated, and that's the work we are doing. Walatu Walasa supports hard work, so hard work must come with good pay, and that's what we want. Now, we cannot be here without talking about the Labor Acts. It's another review, and I know you are part of those ensuring that the right thing comes out after this review. How is the Labor Act in itself like? Give us a brief about it, and where are some of the areas that, as Labor Department, you are looking at to see some kind of change in there?
Yeah, thank you very much. Yes, indeed, the Labor Act is currently ongoing through some reforms, because every day and night, since the economic situation changes, our laws must also change to conform with the standards.
Yes.
And before I even come to that as well, Ghana government is a member of ILO.
Great. The International
Labour Organization.
Yes.
And since 1957, Ghana government joined that union or association. It has never relented on its effort to conform to the standards that is set
by the ILO.
And out of that, Ghana has ratified 52 conventions since 1957, and 37 are in force. 8 has been denounced, 7 has been abrogated.
Yeah.
Now, once you ratify a convention, you are required to ensure that your domestic laws conform to the provisions of that convention.
Very well.
And these conventions are structured into 3 categories: fundamental or core conventions, governance conventions, and then technical conventions. The fundamental conventions, as we speak now, there are 10, out of which Ghana government has ratified 8.
Okay.
The governance ones are 4, out of which Ghana government has ratified 2. But the technical ones, over 200. But Ghana government only ratified 47.
Okay.
So the call for this modification of our laws, especially the Labor Act, has to do with majority of these instruments
that has come out,
that we have adopted, that we have as ratified,
and for that matter, we
must need
follow.
To comply with.
Yes.
Most especially has to do with even now, Ghana government is expected to make a provision in the Labor Act to provide for social scheme for women in terms of those who have given birth or those who are on maternity leave. So that the women will be assessing that when they are on maternity leave, and the employers will no more be paying them salary when they are on maternity leave.
So that scheme will cater for that period.
Exactly. But it is in the convention, we have read the convention 103, maternity convention. Even now there is a revised one, 183.
183, yes.
Which we are struggling to ratify. And which the draft bill has taken cognizance of its provisions, and when the law is passed, or this bill is passed, it will be
incorporated.
Exactly.
We'll see it's there. We'll see it's there.
Exactly. And then we have other things. Aside this, Ghana government is also under an obligation to be reporting annually.
Great.
And that
to ILO.
Yes, to ILO.
About what is doing to the
what you are doing with your convention you have ratified, how you comply with them. You submit a report, data, even include this Workmen'S Convention, which is in reference with Convention 19. You You see where the workman compensation is coming from?
Yes.
Occupational disease.
Yes.
Convention 19.
19 of the ILO.
ILO.
Yes.
That's where it derived from.
Yes.
So we have a lot that we're supposed to do. So even our constitution,
Yes.
provisions are taken from these international instruments,
Yes.
which we have applied. And now we are being faced with equal pay for equal work. But ILO is saying that equal pay for work of equal value.
Can you say that again?
Equal pay for work of equal value. And ours is equal pay for equal work. They say the two are now the same.
Yes.
And that is what is in the convention. And we have informed them that this is what is in our constitution.
Yes.
So the Labor Act that they see had inspiration from the constitution. So anything that we change, anyone who goes to court against that section
would have to refer to the big
in fact, they will
constitution.
quash that particular section cannot stand.
Yes. It has implication.
Yes,
big,
it has
big
implications.
So
that is what is informing now to reform the act. And also there are other sectors that this act did not provide for.
Great.
Seafarers, they are not captured under the Labor Act.
Mm-hmm.
Migration, they are not captured.
Mm-hmm.
A whole lot of them are not captured. So the current bill has considered all these sectors. And even the worst of it all, when you look at the LI 2408, which I mentioned earlier, it has some kind of inconsistency with this act. You see? Because when you look at, they are saying section 33 and 34 is not applicable to the domestic worker. And what does it mean? It's talking about maximum hours of work. And other things.
Yes.
So I mean, they don't have maximum hours. They can work anyhow.
After when the domestic worker is in your house, okay, and you wake up at dawn and there's a water spilled somewhere, if you are whoever it is, go and clean them.
But your work starts from then, so it should be counted with your hours.
Yes, it should be counted, but it is neglected.
It's neglected. So coming back to your issues in respect of the
Labor Act,
the draft bill,
review,
the draft, yes, even. Another issue, I made mention of ceiling in terms of workman compensation. So we are removing, there's not going to be any ceiling anymore.
Okay.
We'll use the actual salary.
Which is on the current situation of time.
Of course.
Yes.
And if your age is less than 50 years, we are going to use 140 months of your earnings to calculate. Okay. But if you are below, you still get your 96. But if you are above 50, but up to 55, we'll use that. But if you are 55 years, we only use the 5 years to calculate for you. So we expect that the new Labor Act that will come out would really meet the test of time and ensure that workers' rights are well protected. Thank you very much. But we are rounding up. Let's look at dealing with informal sector employment, your units. How did they go about the informal sector issues? There's a lot of people. In fact, Ghana's labor is full of informal. Its majority are in the informal sector. How is your unit handling those informal sector workers? Yeah, so this has to do with reforms.
Great.
You see, when you look at the word informal, why are we even referring to them as informal?
Mm-hmm. Because
the activities are not recognized by law.
By law.
You know, once I'm here, I'm talking law.
Yes.
Somebody whose activity is not recognized by law, how do you use the same law to go and regulate the person?
It becomes it's out of place.
So what we can do as a country, or maybe a policy makers, is to look at how best they can bring on board these informal sector workers so that they could remove some barriers in terms of registering their companies or forming associations.
Yes.
But when they form an association, they can register it. When they register, they are no more going to be informal. They will now be formal.
So that all other laws within the formal can apply to them.
Now, when you go there as a labor officer, yes, it's informal sector. The only thing is that You advise them, oh, how much are you paying this person? How much are you doing this? Oh, does it have rest and all? These are the things you are going. If the person does not conform to this, what law are you using against?
So there's a huge gap there.
There's a gap.
There's a huge gap.
I had opportunity to train some of the informal, these domestic workers.
Yes.
On this LI 2408 last year, about twice, even some at the TUC, where about normally 100 of workers were summoned there.
Yes.
So you see that the people don't know what they are doing. So we have a lot to do. As a country, the policy makers to involve these individuals. See, listen to them. What are their concerns? What do they want from government in order to boost their activities? Someone who has put this type of table in front of his house and is selling toffee and other things. You want to regulate this person.
You want to regulate the wache seller.
The wache seller. Even though they make money.
Yes.
They employ people.
Yes.
Because each day everybody must eat. So how do you bring these people on board to formalize their activities?
Yeah. I think this issue has been lingering on for a very long time, and I think we need to take bold steps and ensure that the informal sector are formalized so that we can regulate their activities and make sure that they also conform to the rules and regulations and the acts that we have within our environmental space. Now, let's look at shortly. Tell me something about migration, worker migration within our country.
Okay, thank you very much. When you look at migration, we have various forms of migration.
Yes.
It could be internal or external. When you look at internal, people move from one region or geographical area to another in search of jobs.
Within the same country.
Within the same country.
Great.
Then we have those who want to leave the shores of the country outside to go and work or
Overseas.
see greener patches. That's what people will say. Largely, those that we see are domestic workers like we are talking about. They go there to work in individual homes, which is many times you hear people crying, they are maltreating them, and a whole lot molest. I mean, a whole lot.
Yeah.
And on the basis of this, there was a time government even banned, especially to the Gulf states,
Yes.
for those who have been licensed to recruit these people to not do so, to streamline things.
Yes.
And I believe just yesterday or so, I saw some social media reporting about 130 something.
Going to Antigua.
Exactly.
Great.
To go and work.
But that particular arrangement should have informed the Labour Department or Ministry of Employment is aware.
Yes.
For which I believe documents are moving and it will trigger to your desk.
Exactly. I believe so, but I don't have much facts about that. What I always saw is what I'm saying.
We want to empower the institutions that have the right mandate to do their work to do it. So if there's such an arrangement, I believe that then government should have taken the right steps, because some of issues of compensation and all this can come in. Who deals with it? He's not going to be all the way to pass through the Minister of Foreign Affairs. It will certainly have to come.
We even have to look at under which laws are they recruited. Is it under the Ghana Labour Act or the Receiving Country Labour Act?
Yes, all these comes into
all these things.
Anyway, when we say we want to delve into that, we would go length. Our time is up. But going forward, I think we would come back again and talk much more about the unit, units that you're coming from, and also look at other areas and functions of the Labour Department in general. Viewers, today's discussion has shown us that Labour protection is not only about employment contracts, but also about safety, justice, compensation, and respect for international standards. And that strong labor laws, effective legal interpretations, and fair compensation systems are essential to protecting workers and strengthening confidence in labor institutions. Let me say a big thank you to our guest, Mr. Francis Bubusi Esquire. Thank you very much for coming on Walatu Walasa.
Thank you.
We are most grateful for your insights and all the information that you have given us. Mr. Francis Bubusi Esquire is the Assistant Chief Labor Officer for the Labor Department. Now, let's take a critical look at what I have on my table. I'm sure many of you are admiring and wondering what it symbolizes. This is Walatu Walasa's campaign against illegal mining in Ghana, popularly known as Galamsey. Walatu Walasa is appealing to the conscience of all those involved in this brutal act, right from the top of operations to the lowest person involved in Galamsey, to take a look into the future of our country, Ghana, and put a stop to this act that will destroy our beloved country. Ghana needs clean water. We are calling for responsible mining, which we believe falls within the environmental balance of our country. What we need is clean water. You can see the mystery pipe explaining clean water. Of course, we need clean water. The water that we see today, because of Galamsey, is very bad, and this will go a long way to destroy our water bodies in future. Thank you for staying with us on Walatu Walasa, where we keep the spirit of work and dignity alive. Work hard, stay focused, be productive, and on a very good day, don't break the rules. See you next week. Bye-bye.
Walatu Walasa, Nadia Wonso.